Immediately on the moratorium coming to an end, the appellant approached the authority requesting them to accept the settlement amount under the scheme 2019 as per the form number 3. Such request has been rejected by the Commissioner. On the rejection has been confirmed by the High Court stop. Therefore, the short question which is posed for consideration before this court is whether, when it was impossible for the appellant to deposit the settlement amount in view of the bar and the restrictions under the IBC, the appellant can be punished for no fault of the appellant. In a given case, can the appellant be made to suffer for no fault of its own and be referred remediless and denied the benefit, though it was impossible for the appellant to carry out certain acts, namely to deposit the settlement amount during the moratorium stop as per the settled position of law. No party shall be left remediless, and whatever the grievance the parties had raised before the court of law has to be examined on its own merits. Stop as observed and held by this court, no law would compel a person to do the impossible. Stop para. Learned counsel appearing on behalf of the state while opposing the present appeal has vehemently submitted that in the present case the dead body was exhumed from the place shown and identified by A1. It is submitted that the place of burial shown by A1 and the identification of the body by him has been duly proved by the prosecution. Stop. The evidence of anthropology of expert is accepted. Stop. It is submitted that even the stolen car was also recovered on the basis of disclosure statement made by A1. Stop. It is submitted that engine and gear box were found to be in custody of PW 17 on the basis of disclosure statement made by A1. It is submitted that PW 17 has deposed that some parts were sold by A1. Stop. It is submitted that aforesaid crucial circumstances have not at all been explained by the accused in his further statement under section 313 CRPC. Stop. It is submitted that deposition of DW1 has been rejected by the courts. Stop. It is submitted that therefore no error has been committed by the courts below in convicting the accused for the offence punishable under section 302 and other offence of IPC. Stop para. Making the above submissions, it is prayed to dismiss the present appeal. Stop. We have heard learned counsel appearing on behalf of accused as well as the state. Stop. We have gone through the findings recorded by the learned trial court as well as the High Court while holding the appellant accused number 1 guilty for the offence punishable under sections 302 and 201 of IPC Stone. It is the case on behalf of the appellant accused number 1 that he has been convicted on the confessional statement and therefore in case of circumstantial evidence and unless and until the complete chain of events were proved and established, the he could not have been convicted on confessional statement stop, however, from the judgment and order passed by the learned trial court as well as the High Court, it cannot be said that the appellant has been convicted on the basis of confessional statement stop in the present case. There is no confessional by the accused that he committed the offence which has been but relied upon by the court. The so-called communication by the accused is as such not believed by the High Court stop para. However, at the same time, it can be seen that the communication or letter received by police on 30/12/2007 was the cause for reopening of the case as earlier the case was closed on 04/02/2007 as untraceable.